As I said, these have all been downloaded from Sector. Let's start the first one, the process of a criminal matter. And we're going, with this, we go right back to the start of the legal process. Right? And we say, okay, this is all about a person ending up being arrested. And we start with the police officers. So there's a special act that gives police officers the power, the Police Powers and Responsibilities Act. So they can arrest a person. To do that, they have to give them the offence that they're being held for, so what they're doing that they've been accused of doing the wrong thing, and the rank of the officer. If you're arrested, you don't have to tell the officer anything other than identifying information, right, your name. This is part of the idea of the right to silence. We'll talk about this later on in all the rights, but you don't have to talk at this stage. Right? The idea being that you don't want to incriminate yourself, you don't want to say silly things. You have got the opportunity to contact a lawyer or a friend. Now we come to an important element, and that is bail. So bail is your undertaking that you're going to show up at court. And usually what they get to do is they get you to leave a sum of money proportional to what you might have. So a very wealthy person might have to leave $1 million in bail. A student might only have to leave $20 or $30 in bail. But that is on the basis that people are going to actually attend court. And there's a bunch of risks that we say, okay, here are the things that a person who's at risk of will not be allowed bail. They won't be allowed to go. So if there's worries about them failing in the court, if there's worry about them committing another offence, if there's worries about them endangering the safety of other people or interfering with witnesses, they won't be given bail. And the first part of the criminal process is the committal hearing. It's separate from the rest of it. This is held in the magistrate's court and just looks to check that there's enough evidence on face value for there to be a court case. So the police would have to show they've got enough evidence to make a reasonable case. So that's the first slideshow we've got there. Let's move on to our second. Now we go to the court processes. So what comes after, in a criminal case, what comes after the committal hearing, where they've decided that there is enough evidence to go. Now we've already talked, the first part of these notes talks about the committal hearing, but we've already talked about this. So let's move on. First thing we've got to be able to do is put the right court to the case. Okay, so we're saying, is it a minor matter? Does that happen in the magistrate's case? Maximum penalty of up to 2 years. The district court, maximum penalty up to 14 years, or the Supreme Court above that. So that's something you're going to have to do in the exam. I'm going to say someone's been arrested and they face a maximum penalty of 18 years for aggregated assault that led to harm. Which court would it be in? You'd have to say that's the Supreme Court. Now we get to the plea. And this is where they'll say we're either guilty or not guilty. If they say you're guilty, if the plea is guilty, you go straight to sentencing. We don't need to have a jury. We don't have to go through any of those steps. But if they say not guilty, then we go to looking at the evidence and a jury making that decision, and then the judge will make the sentence. Prosecution, they present their case first. And most of us, when we looked at it, we agreed that going second would be an advantage, so the defence gets that. So the prosecution, they're the ones saying this person's guilty of the crime. And they will bring their witnesses and their evidence. And then, after both sides are presented, the judge does a summary. And the judge makes sure that the jury understands what the law is. So, for example, they might explain what the difference between manslaughter and murder is. Then, the jury goes out and decides, is it guilty or not guilty? And remember that it has to be, in most cases, a 12-0 decision. All 12 people have to agree guilty or not guilty, otherwise it goes to a retrial. And then there's the sentence. The judge considers a whole lot of factors, including maybe previous criminal history, maybe there's a really young person, and puts together a sentence that might include jail time, a fine, community service, or a suspended sentence, which we already talked about, means if they do something wrong again, they have to go and serve that sentence. Okay, that's the second lot. Let's move on now to the aims of punishment. And this is important because, and you can imagine we're talking about suspended sentence, I'm going to be asking us a question around what the aims of punishment are. So there are a number of aims that are set out in Queensland in the Penalties and Sentences Act 1992. Again, if you can remember that, that'll get some extra kind of marks because you recognise the legislation where something comes from. So the aims are to punish in a fair way, to help with rehabilitation. So that means to make someone, put them in a position where they're not reoffending again. The classic example of that would be drug use. So if someone who has offended because of drug use, they might go and they do some programs in jail where they're not using drugs so much. To deter, that means to stop the person from doing it again. So if they have a consequence, they're less likely to do it again. To make it clear that community denounces doesn't approve of the offender's conduct. So it's a way of saying this, what they've done is wrong, so they have to have a punishment to show everyone in the community that this is the wrong thing to do. And then the last one, to protect the community from the offender. In Australia, we don't have the death penalty, we've only got jail, but jail would be a way of protecting the community from offender because someone can't get out, let's say they've been involved in assault, they can't get out and assault someone while they're in jail. And we go into these in a little bit more detail. Retribution is the idea of an eye for an eye. So if something bad, so this is this first one, that someone's punished in a fair way. If something bad has happened to someone as a victim, then something bad should be happening to the person who does it. Rehabilitation, getting someone back to normal life. Deterring, so that the idea that no one will want to do this because they can see there's a punishment attached with it. Denunciation, it's the wrong thing, it's disapproved of. And prevention, right, we stop people from reoffending. Jail is the idea there. So we're getting very close. Let's see. I think we've got the rights in the criminal process. This was not in your revision sheet, I think, because we hadn't gone over at this stage, or was it? It may have been in there. But just be aware, particularly aims of punishment wasn't. So rights in the criminal process. Right. The Universal Declaration of Human Rights, again, if you know that as a document, talks about three rights: the presumption of innocence, the right to legal representation, the right to silence. Okay. You've got a right to be presumed innocent. At a practical level, this is most commonly seen by the fact that you can't have your previous criminal history brought up in the trial. The jury doesn't know about your previous criminal history, so you have to be convicted purely on the facts of the current case. The right to legal representation, okay, that generally means the right to have a skilled professional represent you. In Australia, we have legal aid, which will provide representation for people who can't afford it. And the right to silence. When you're arrested, you don't have to say anything. When you're in trial, you do not have to say anything. You have that right to silence. And we've got a little bit of a puzzle because I feel like there's one that we've looked at yet. We've looked at the process, some rights. And let's just go through this is certainly the last one. Just a few extra things around the criminal process. Some we will have already touched on, so we've already talked about the committal hearing. Okay, we've heard that that's held at the Magistrate Court, just to check there's enough evidence. Oh, actually we've looked through this one. I thought there was... Okay, just check. We've been through that. Yeah, I think we've been through all of those, guys.